Rashida Manjoo, the UN Special Rapporteur on Violence Against Women, Its Causes and Consequences, said in 2014 that violence against women in India is systematic and occurs in the public and private spheres. It is underpinned by the persistence of patriarchal social norms and inter- and intra-gender hierarchies. Historically, as well as today, most positions of power are held by men, and the idea of what rights are has been defined by men and represent male needs. Fuller legal protections have been given to the public sphere, for example, employment, civil and political activity, where men have historically been more active than the private sphere, for example, rights within the home and within marriage, regarding separation and divorce, and where women tend to be more involved as weaker, more dependent agents. Historically, only men could be drafted to serve national service and to become combatants in the armed forces, and only men could claim social security in times of disability or unemployment. These notions reinforce gender stereotypes. Men could also be responsible for overseeing estates in the cases of inheritance, not like women. Women, unlike men, were entitled to receive maintenance to look after children. These social welfare systems were often built on the assumption that wives, but not husbands, were economically dependent on their spouses for support. Laws typically accorded automatic benefits to female survivors, but required male survivors to prove their financial dependency upon their spouse. This often involved stringent financial tests. Similarly, in the Netherlands, if men claimed disability-related financial support from the state, they were automatically entitled to the welfare. The reasoning behind this is that men are financially independent and are not dependent on anyone for their survival. However, if a woman was married and wanted to seek disability support, she first had to prove that she could not rely on and be supported by her husband before she would be entitled to any social welfare benefit. Such laws have negative consequences for couples that do not conform to the expected social norms. If a family has a woman as the primary income earner and she was injured during an employment-related activity, her family would not be able to claim social welfare support. Even recently, when domestic laws have tried to be reformed, they have met opposition. In 1972, both houses of Congress in the USA passed the Equal Rights Amendment Act, otherwise known as the ERA. The ERA promoted equality between men and women and was often seen as a central feature of the feminist agenda, despite the amendment only having a limited scope whereby it could hold the actions of the government accountable and did not extend into the private sphere. There was significant resistance to it being implemented. Discrimination by employers, banks, insurance companies, or other non-governmental entities were not covered. Because of this resistance, the ERA was defeated and never came into force in 1982. Similarly, in Australia, the introduction in 1984 of the Sex Discrimination Act was limited to particular areas of public life, for example, employment and education, and specific grounds of discrimination, including sex and marital status. Discrimination in the private sphere perpetrated by non-state actors was left without legal protection. Law in itself, therefore, may not provide women with equal rights, such as to claim social welfare support, and it thus denies them real, de facto, or lived equality. This may be because law may fail to give protections to women, for example, where there is no workplace protection from discrimination or gender stereotyping, and there is no equal pay legislation or parental leave. In some cases, the law may provide women with equal rights, but these rights are not translated into equal rights either because the system, such as the courts, judges, and access to quality legal representation, is overwhelmingly male and represents male experiences and perspectives. It therefore doesn't recognize her specific gender-related needs. Another barrier to law providing solutions for gender equality is that laws in themselves cannot transform social values within society, and courts are not sensitive to the experiences of women, and therefore cannot fully comprehend the harms they suffer. If courts cannot comprehend these harms, they find it difficult to provide a suitable solution. Since the 1970s, laws have started to be challenged and changed as a result of greater awareness about gender discrimination. In some cases, it has even been credited as fundamentally changing the legal and social environment that it operates within. But amendments are often patchy and sporadic, and the lack of support structures to address systematic discrimination do not address structural disadvantage, especially within the private sphere. An example of this is legislation on domestic violence. Privacy laws, for example, have been in existence since the late 1800s in the USA, where a landmark journal article was titled "The Right to Privacy." This article was published in the Harvard Law Review in 1890. The article established an individual's right to privacy and freedom from arbitrary interference by the state in all of the individual's private matters. In 1968, when the American Convention on Human Rights was drafted, it included in Article 11 the right to privacy. The article stated that no one may be the object of arbitrary or abusive interference with his private life, his family, his home, or his correspondence, or of unlawful attacks on his honor or reputation. This provision, amongst many national variations of the same theme, recognized men as the sole property owner, head of the household, and therefore the rights holder. Privacy was thus his right to be free from interference by the state or church, and included his rights over those in his control in the private realm, such as women, children, and servants. Privacy laws have therefore often aided the exclusion of perpetrators of domestic violence from the scope of law. If police are notified of a physical, verbal, or other form of domestic violence, and the perpetrator of the violence opens the front door, he could easily say that it was a private or domestic matter, and the police would therefore have no legal grounds to intervene. Any such intervention within the private sphere would have been seen as a violation of the legitimate extent of the power of law. It was only in 1991 that the UK law lords ruled that marriage was a partnership of equals, and no longer one in which the wife was to be subservient chattel of the husband. Consent for sexual intercourse, previously assumed to be given at marriage, and which could not from then on be retracted, was overturned. This landmark decision overturned a principle of privacy that can be traced back in the UK law as far as 1736, when Sir Matthew Hale said, "But the husband cannot be guilty of rape committed by himself upon his lawful wife. For, by their mutual matrimonial consent and contract, the wife hath given herself up in this kind unto her husband, from which she cannot retract." This judgment was a momentous turning point in UK law, when a centuries-old thinking, protecting the rights of man within the private sphere, and therefore nullifying women's ability to seek legal redress, was overturned. In 1994, the Federal Violence Against Women Act was passed by the US House of Representatives in the USA, and even then with a bipartisan vote of 235 to 195. In other words, only 40 more voting representatives approved of the Act over those who did not vote for its enactment. This demonstrates significant resistance to its passing. As the Act is federal, it ensures that all states across the USA have the same protections to survivors of gender-based violence, and that if a perpetrator resides in a different state, arrest warrants may be issued and served and executed. This means the survivor of the domestic violence can still take the perpetrator to court, even if they are then living in different states. Within India, it was a decade later that the Protection of Domestic Violence Act 2005 came into force in 2006, giving women a substantive definition of domestic violence and specific protections to supplement the general provisions of the Indian Penal Code. Such recent inclusion of law that represents the lived experiences of women demonstrates how weak and quiet women's voices have been within legal frameworks domestically in the East and in the West. Internationally, the Convention for the Elimination of All Forms of Discrimination Against Women, which was drafted in 1979 and came into force in 1981, does not contain a provision protecting women from intimate partner violence. It wasn't until 1989 that General Recommendation 12 on Violence Against Women and a second recommendation of the same title in 1992 that domestic violence was read into the protections of the Convention. India has several women-specific laws. Amongst these, the Indecent Representation of Women Prohibition Act exists. This was drafted in 1986. The Commission of Sati Prevention Act from 1987. The Dowry Prohibition Act from 1961. And the Protection of Women from Domestic Violence Act 2005. Further, the Protection of Women from the Sexual Harassment at Workplace Act, Prevention, Prohibition and Redressal from 2013 also came into force recently. Whilst the content and intention of these acts is to reduce the social discrimination and consequences that women experience, there has been limited training and sensitization regarding how to interpret and apply these provisions. This has resulted in interpretation and implementation of the law that is not always compatible with the law's intent. In 2013, Judge Kailash at the Delhi High Court stated within a judgment that rape cases are being used as a weapon for vengeance and vendetta, to harass and even force a boy to marry. Even the Central Sexual Harassment Act that mandates hearing committees within public and private organizations to attend a training every year does not have an accompanying training program. Such voids in fulfilling law to make it meaningful results in weak understanding and implementation, where cultural and patriarchal views, not gender-sensitive, rights-based opinions, are passed down as authoritative decisions. Domestically, the Prevention of Crimes in the Name of Honour and Tradition Bill 2010 is still pending before Parliament. The bill, which in December 2014 received the support of 22 states and union territories, has not been given a timeline for implementation by the central government. Similarly, the Women's Reservation Bill, seeking 1/3 representation of women in the Lok Sabha, first presented to Parliament in 1996, and more recently, the Women's Reservation Bill, the Constitution 198th Amendment from 2008, have failed to be enacted. Marital rape, despite the recommendations of the Vidya-mitra Committee, is still not criminalized under the IPC. In addition to a host of crimes that disproportionately affect women in society, there is also a significant lack of gender sensitivity towards rights-based equality within the judiciary and the executive. This often results in inappropriate statements from politicians and unfair judgments in court cases that often amount to victim blaming and fail to place the blame, shame, and stigma of the violence on the perpetrator rather than the victim or survivor. In 1972, a 14-year-old girl was raped in police custody by 2 policemen. When the case went to court, the Supreme Court judgment in 1979 overturned the Bombay High Court judgment and ruled that the policemen were not guilty. The Mathura judgment failed to place the blame for acts of sexual violence with the perpetrators, and therefore failed to fulfill their constitutional provisions towards equality and to the legal protection of all citizens. The Supreme Court justified its decision with a combination of prejudice towards the young woman who was sexually active in a consenting relationship outside of marriage, and with sweeping, derogatory and demeaning subjective opinions which failed to deliver a rights-based decision. The court stated that she was habituated to sexual intercourse and therefore was less likely to have been raped. This is a clear failure to demonstrate an understanding of the difference between intercourse with consent and intercourse without consent. One with her partner near her age and the latter with an unknown policeman in a police station latrine. Further, the judgment states in paragraph 13 that now the cries and the alarm are, of course, a concoction on her part. But then there is no reason to disbelieve her assertion that after Babu Rao had recorded her statement, she and Gama had started leaving the police station and were passing through the entrance door when Gunput, the appellant, caught hold of her and took her away to the latrine. And if that be so, it would be preposterous to suggest that although she had practically left the police station, she would be so overawed by the fact of the appellants being persons in authority, or the circumstance that she would make no attempt at all to resist. On the other hand, her natural impulse would be to shake off the hand that caught her and cry out for help even before she noticed who the molester was. Her failure to appeal to her companions, who were no other than her brother, her aunt, and her lover, and her conduct in meekly following Gunput the appellant and allowing him to have his way with her to the extent of satisfying his lust in full, makes us feel that the consent in question was not a consent which could be brushed aside as passive submission. The court's decision that her claim that she tried to raise the alarm are a concoction. The assertion that it would be preposterous to suggest that she would make no attempt at all to resist, and that she followed the policeman meekly and allowed him to have his way with her, all completely fail to understand the vulnerabilities of a 14-year-old girl in a police station. The comments suggest there should be one method of reacting to a previously unexperienced situation, and that all young women must comply with or else be found wanting of belief. It reinforces a gender stereotype where women must scream and resist or else be complicit. It also suggests that if a woman is sexually active, she must be willing to engage in any other sexual activity regardless of whether choice, consent, or coercion exist. The judgment completely fails to show any sensitivity or understanding towards the reaction of a 14-year-old girl who had been restrained and dragged away by a policeman who was in uniform in a police station. In 1992, Banwari Devi, a social worker from Rajasthan, was raped by a group of upper caste men in her village as revenge for trying to prevent a child marriage, thereby challenging traditional practices. The local sessions court in Rajasthan dismissed the case on the grounds that upper caste men wouldn't rape a lower caste woman. They further added that a man who was an uncle would certainly not rape a woman when his nephew was present. This judgment again fails to recognize the power dynamics of sexual violence and how rape can be used as a tool to try to enforce conformity with caste roles and traditional practices. This judgment again fails to recognize the power dynamics of sexual violence and how rape can be used as a tool to try to enforce conformity with caste roles and traditional practices. The judgment also fails to deliver a sensitive and rights-based form of redress to the survivor of the violence. The influence of patriarchal thinking on the conduct of the judiciary and other state agents is unfortunately still present in society today. In 2008, after a journalist was shot dead whilst driving home from work at 3 a.m. in the morning, the then Chief Minister of Delhi, Sheila Dixit, issued a statement saying, if she was out at 3 a.m. in the morning, she was being too adventurous. In 2013, AP Singh, the defence advocate for the accused in the Nirbhaya rape case and murder, on television publicly stated that he would burn his own sister or daughter if she engaged in premarital sexual activity. In 2014, Mamata Banerjee, the Chief Minister of West Bengal, stated that the public outrage over the Kolkata gang rape incident was a conspiracy to impede development work by her government. Such comments from politicians and from judges demonstrates how deeply ingrained patriarchal views and victim blaming are within the social fabric. They also demonstrate the serious need for gender sensitivity and rights-based justice training for members of the judiciary, legal profession, and politicians to bring tangible change for women's rights and implementation of existing laws. The above examples range from the socio-economic position of women in society, which reinforces women's more vulnerable and inferior social position, the lack of prioritization of women's issues in the allocation of state funds, to laws that do and do not exist, and their gender-insensitive implementation, demonstrating why special measures are needed to promote the substantive upliftment of women. This module is now complete.